Great. Let's get started, folks, and good to see you all. My name is Mindy Luber, and I'm the CEO of Ceres, and welcome to our webinar today. Just a quick background: for 32 years, Ceres has worked with the most influential capital market leaders to integrate sustainability into capital markets. You can imagine how well that worked 30 years ago. Obviously, today is a whole different world. We are a nonprofit, nonpartisan organization that mobilizes networks of large investors and companies. Our investor network includes 210 institutional investors managing more than $49 trillion in assets under management. And globally, through our priority initiatives like Climate Action 100+, we work with and convene more than 650 investors who are collaborating on climate action. And our company network and policy networks, most of whom are Fortune 500 companies and number around 100, are companies who are helping to integrate sustainability from their boardroom through to their supply chain. Today, we've got some terrific speakers, not the least of which is the chairman of the U.S. Securities and Exchange Commission, Gary Gensler, who I'll introduce in more detail later. But the chairman will give a keynote set of remarks. And following him, Renee Jones, the director of the SEC's Division of Corporate Finance, will join us as well. And from our team at Ceres, Isabel Muna, who is our director of U.S. Financial Regulation, will share reactions and specific details and recommendations to the SEC's proposed climate disclosure rule, which runs over 500 pages and is chock full of detail and really important and crucial recommendations. And following that, Stephen Rothstein, the managing director of the Ceres Accelerator for Sustainable Capital Markets, will share opportunities for engaging and next steps. And then finally, Kirsten Spalding, my colleague who runs our Investor Network program, will share reflections and bring in 4 thought leaders, 2 investors, one from Franklin Templeton, one of the leading thought leaders, and another leader from Neuberger Berman, and then 2 companies from our networks, including Jones Lang LaSalle and Salesforce. Today, we've got over 2,100 people registered. That's not to tell you we know how to count in big numbers. We've got investors, companies, government officials, trade associations, academics, media, and the public. But the point is really the interest that we're seeing around this rule. Last week, I spoke to hundreds of women corporate board members, all of whom managed to tell me that this issue has created more static, more interest, more engagement at their board level, which is where it belongs, than any issue they can remember. So lots of interest, all good. And feel free to post the live stream link on this on social media with hashtag Climate Disclosure Now. We're also live streaming today's event and we'll make a recording available. So let me say the obvious. We're delighted you're joining us, and delighted because it's a critical moment. We're all tired of reading the IPCC reports, the other science reports, in how serious the problem is. And the solutions to the problem are there, and they need to keep up with the severity of the problem. And part of it really runs to the most basic, but also one of the most important things, and that's covered in the rulemaking process we're talking about. The rulemaking that the SEC is involved with related to mandatory climate risk disclosure is crucial. You can start by developing your own comment letter and making sure the SEC hears from you. But clearly, this is a crucial measure, and we want to make sure you have the information you need and the follow-up happens. So climate risk, why climate risk? The financial risks are growing every day. We know that the risks facing companies, their short shareholders, as well as people who own property, people have insurance, those risks are growing every single day. It's not anymore about the future, it is about now. Climate risks are physical risks to start, they're financial risks. They're here, they're costing billions of dollars, damage from floods, storms, wildfires, droughts, and the list goes on. The Dallas Fed last year said that the cost of the 2021 Texas storm that took 111 lives. Now let's start with the importance of that before we worry about numbers, although the numbers are huge. Took 111 lives and cost over $100 billion. with estimates of insured losses at $10 to $20 billion. That is real risk. And according to the federal government, last year, climate-related disasters cost our nation $145 billion. And there are transition risks, everything about moving to a different kind of economy. Every country is looking at policy. They're looking at regulation. We're all looking at technology and consumer preferences. We need to be on top of that, get in front of it, and having clear disclosure will help us get there. We're talking about a risk that's likely to be larger or greater than the subprime meltdown, clearly worthy of our attention. The climate science has never been more clear. The latest IPCC report warns us of the urgency to take these threats seriously, and they tell us two other things. One is the window to act is rapidly closing. We can't put this off and start in 10 years. Every day we put it off, it gets more complicated. And the second thing is the time to act and the opportunity to act exists, and we can still get on top of the problem, but we don't have a lot of time before it becomes nearly impossible. So we will look at the opportunities as well as the risks, not all on this call, but they exist and they're there. Given the scale of these risks, we're seeing markets, we're seeing regulators around the world addressing it. 8 countries already require standard climate disclosures. Many more are looking at it. Central banks are considering how to move. Federal banking regulators have proposed guidance on climate risk for banks, and we know more is on the way. The Federal Housing Finance Agency and the Commodities Futures Trading Commission are already moving forward to address climate risks, and the SEC, with the important groundbreaking draft rule, is doing exactly the same. This is important, and we look forward to the chairman telling us a bit more. So very quickly, since then, we've seen clear progress. We see private progress. Companies, investors are moving. Companies are putting more information out into the marketplace. Most of it's voluntary reporting, which clearly is a start, but it is not good enough. We need mandatory disclosure. We need consistent disclosures that reduce inefficiencies. We want information to be accessible, clear, real, and consistent. And right now it's not. It is inconsistent, at times incomparable, and in many cases not a strong enough quality, thus the need for the SEC. The investors we're working with feel like they're flying blind on investment decisions in their portfolios. You know, it is true, we've said this 1,000 times, but you can't manage what you do not measure. It's simply impossible, which is why hundreds of the investors we work with really do believe that the SEC is leading and doing what makes sense. And those very same investors have been supporting the task force on climate-related disclosure, the TCFD, which is an underpinning of the SEC rule that you're going to hear about. 733 investors with $52 trillion in assets called for mandatory corporate climate disclosure. That's very real support. And our analysis of last year's SEC comment files showed overwhelming support, with 70% of the comments were investors asking for TCFD-aligned disclosure and 65% calling for emissions disclosure. Overwhelming support from investors and support from companies for the harmonization of global standards, for mandatory standards, and for equivalency. The momentum keeps growing. It's impressive, whether it's the calls for TCFD or just this week, the IFRS Foundation, which produces financial reporting standards used by 140 jurisdictions around the world, just launched their proposed climate disclosure standards, also based on TCFD, consistent with the SEC and worthy of our support. So we're seeing global convergence and harmonization, exactly what investors and companies have asked for. And investors and companies are leading the way. Over 3,000 companies are using TCFD as a benchmark. And the world's largest asset managers are asking the portfolio companies that they own to provide for them a TCFD report. And businesses, 92% of Fortune 500 companies are reporting voluntarily, but using science-based targets. We've got to move that to mandatory. And finally, the public does support this. It is not only investors, and clearly more investors than companies or policymakers, but the public recently said in a poll by Just Capital that 87% of Americans agree that the federal government should require large companies to publicly disclose climate risks. So crucial to keep this momentum going. The chairman will talk about the importance of your comments. Supporting the SEC and their draft rule, in our judgment, is extraordinarily important if we are to collectively provide a level playing field for all publicly traded companies, allows us to keep up with the many European countries that are moving, and really provides material risk information and climate disclosure information that the public needs, that investors need, and that we need to integrate and to address climate risk. So let me stop there. It is my distinct pleasure to introduce the chairman, SEC Chair Gary Gensler. Gary is a leader who understands the magnitude of the climate-related financial risks we face. He has done Herculean work to propose a draft rule that they call Enhancement and Standardization of Climate-Related Disclosures for Investors. And before becoming the chair, he was a professor at MIT Sloan School of Management and a chair of the U.S. Commodities Futures Trading Commission. It's an honor to welcome you, Mr. Chairman. Deep thanks to you and your entire team for the extraordinary work for the proposed rule. And you need to call on us, count on us to tell us what you need to get the job done. But moving from this draft rule to a final rule is crucial. And we're here to learn more, to offer comments, whether it's on the call today or in the draft, the comment period, and to make sure you have what you need from leading capital market companies and investors. Over to you.
Thank you so much, Mindy. And it's good to be with Ceres today for this investor briefing. Let me just say, as is customary, I'd like to note that my views are my own, and I'm not speaking on behalf of any of the staff or fellow commissioners. So that's out of the way. As you all know by now, as Mindy said, in March, the commission voted on a proposal to mandate climate risk disclosures by public companies. Let me try to put this proposal into the context of our long tradition of disclosures. The core bargain from the 1930s was and still remains that investors get to decide which risk to take. And as long as public companies provide full and fair disclosure and are truthful in those disclosures. And over the generations, the SEC has stepped in when there's significant need for the disclosure of information relevant to investors' decisions. And that's where we are right now, by the way. The first disclosures revolved around companies' financial performance. Who runs the company, how much the company's resources were dedicated to paying the executives and the like. In addition, over time, historical information, though, investors wanted to assess risk as well. Risk, by definition, often involves events that have not yet occurred, the future. So back in 1964, the SEC started to offer guidance about disclosure of risk factors. The agency later adopted disclosure requirements related to management discussion and analysis, late 70s. Then they also added environmental related disclosures dating back again to the 1970s. The commission elaborated on all of these requirements in subsequent decades, but also in 2010 put out guidance regarding climate related disclosures. Across all of these disclosures, the same principle applies again and again. Investors get to decide which risks to take as long as the public companies provide full and fair disclosure and are truthful in the disclosures. Further, the SEC has a role to play, as it has for 88 years, as it can now, play a role in bringing some standardization to the conversation, which is already happening between issuers on the one side and investors on the other side, particularly when it comes to disclosures that are material to the investors. And in making decisions about disclosure requirements under the federal securities laws, including decisions about the proposed climate-related disclosures, I am guided by our three-part mission: protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. But I'm also guided by that concept of materiality. And as the Supreme Court has explained, information is material if, quote, there's a substantial likelihood that a reasonable shareholder would consider it important, end quote, in making an investment or voting decision. Or they went on and said, does it have, quote, significantly altered the total mix of information made available, end quote. Forward-looking statements such as forecasts and risk also can be material. And their standards, both from the Supreme Court and the Commission, have articulated this. I believe the proposed rule would build on that long tradition. It would provide investors with consistent, comparable, and decision-useful information for their investment decisions. It's up to them, their decisions, but it's consistent, comparable, decision-useful information for investment decisions, and provide consistent and clear reporting obligations for issuers. So now let's look at today's practices. Here's the thing. Climate disclosures are already happening. And today, investors are already making investment and voting decisions using information about climate risk. Today, hundreds of companies are already disclosing information, and that conversation is already going on. Many of the existing disclosures build upon, as Mindy said, the Task Force on Climate-Related Financial Disclosures, TCFD, and the Greenhouse Gas Protocol. Let's look back, though, for a second. The TCFD was formed in 2016. They published the report in 2017, reporting into the Financial Stability Board of the Group of 20. The task force, though, comprised then and now about 30 plus market folks, not government officials, market folks, investors, and issuers, some academics who came together to create a climate disclosure reporting framework. 5 years on, this TCFD framework has been used by thousands of companies across the globe as a basis for reporting climate risk information. And beyond that, many countries already have started to develop reporting regimes to build on and incorporate that framework, including Brazil, the EU, Hong Kong, Japan, New Zealand, Singapore, Switzerland, and the UK. One report actually found that 70% of companies in the Russell 1000 index, that's here in the US, published sustainability reports in 2020 using various third-party standards, which includes information about climate risk. SEC staff, as part of our work, actually went back and looked at 7,000 annual reports from 2019 and 2020 and found that a full third included some disclosure related to climate change. Today, investors representing literally tens of trillions of dollars support climate risk disclosure. I don't really need to say it to this group because so many of you are those investors. And why is that? It's because you all, investors, recognize that climate risk can pose significant financial risk to companies. And investors need reliable information about those risks, those climate risks, to make informed investment decisions. For instance, investors with $130 trillion of assets under management have requested companies disclose climate risk. And that information can influence shareholders' evaluation, risk management, investment decisions to buy and sell and vote proxies. So companies and investors alike would benefit from clear rules of the road in the release. I believe particularly those rules reflect what is becoming widely accepted around the globe. It makes sense to build on what so many companies are already doing to enhance, again, consistency, comparability, decision usefulness. So let me just say a few words about the proposal, and I'm sure your briefings today will give you more. The proposal thus really draws on this long tradition of what's currently happening. First, we looked at this and said, these disclosures ought to be, and this is the proposal, be filed in the 10K rather than solely on a company website or elsewhere. And you might say, why? Well, investors look for relevant information in filings like 10K when assessing an investment decision. That was true when I was on Wall Street. several decades ago. It's true now. It's true of the management discussion and analysis sections. It is true of the risk factors I mentioned that came about in the 1960s. It's true of the environmental disclosures that were started in the 1970s. It's true for other key disclosures today. It is important that investors be able to find consistent, comparable, decision useful information in one place rather than sort of looking around and having to piece together information from different locations that might in turn differ from one issuer to another. How do you do consistency unless you have it in a similar place? Further, placing disclosures in filings also benefits investors because there are more controls around the disclosures with a framework required under the Sarbanes-Oxley Act called Section 302. Now, there are some costs to this, but on balance, I believe this consistency, along with the enhanced control environment, brings greater benefits and efficiencies to these disclosures. But we look forward to hearing from you on that, of course, in your comments. Now, a few days after the SEC's proposal came out, the International Sustainability Standards Board made its own proposal on climate related disclosure requirements, and it too proposes the climate disclosures as part of the general purpose financial reporting. This is just amongst one of many similarities to what we put out. Now, in terms of the disclosures themselves, not the placement or location, but the disclosures themselves, first starting with strategy, governance, risk management, and targets. This helps bring some consistency and comparability to what the management teams are already disclosing: strategy, governance, risk management, and targets, building upon the TCFD framework. The second is disclosure for companies that set targets or use internally developed target plans, transition plans, scenario analysis, carbon pricing as part of their risk management. If you, the reporting company, and there are reporting companies listening here today, have a target, under the proposal, you'll need to disclose your plans to get that target, to that target. If you have a transition plan, you would need to provide disclosure about the plan. If you employ scenario analysis or internal carbon pricing as part of your risk management, then again, disclosing that as well. But it's up to the company to determine whether to have a target, whether to have a transition plan, a scenario analysis, carbon pricing. If a company chooses not to make those statements or use those tools, no disclosure would be required. The decision on whether to make those statements or these statements or use the tools, though, remains entirely up to the company under the proposal. Again, we want to hear about that. But to the extent that the proposed disclosures would include some forward-looking statement, such as projections about future risk or related targets or transitions, the forward-looking statement, safe harbor in a law that was passed 25 years ago, the Private Securities Litigation Reform Act, would apply to these forward-looking statements. So we have a disclosure-based regime, not a merit-based one. Thus, the design of the proposal is consistent with those long traditions and the law, with concepts of investor decision-making and related materiality, and with what companies are already doing based on TCFD and the GHG protocol. Second area of disclosure, the first one was pretty big, I know, but second area is financial metrics. The proposed rule also would require a company to disclose, quote, certain disaggregated climate-related financial statement metrics. These are the ones mainly derived from existing financial statement line items. This would include the impact of climate-related events and transition activities on the company's consolidated financials, the current financials. Not so much about the future, but the current. And then next, greenhouse gas emissions. The proposal addresses this because, again, investors are already looking at this and making investment decisions around greenhouse gas data. And such data could present risk, climate-related transition risk. So the risk could include regulatory, technological, market risk driven by transition to lower greenhouse gas emissions in the economy, which has potential financial impacts on revenues, expenditures, capital. The proposal has that all filers would disclose what's called their Scope 1 and Scope 2 greenhouse gas emissions, emissions that result directly or indirectly from facilities owned or activities controlled by the registrant. Thus, these data should be reasonably available to issuers. Now, about Scope 3, under the proposed rules, some registrants also would be required to disclose what's called Scope 3. You know, the emissions upstream and downstream the value chain, but only if such emissions were material or if the company had made a commitment that referenced Scope 3 emissions. So if you've made a commitment or if the information is material, it makes sense to measure and report it. The Commission proposed different requirements for Scope 1 and 2 on the one hand, as opposed to Scope 3 on the other, as methodologies for determining Scope 3 emissions currently aren't as well developed as the others just yet. And the proposal would phase in Scope 3 a little later than the Scope 1 and 2, set a new liability safe harbor with regard to Scope 3 disclosures, and small reporting companies would be exempt from Scope 3. So let me close on feedback from the public, because this is just a proposal. And since the proposal has been released, we've already gotten a lot of feedback, some of it for the proposal, some against. That's what we need to hear. And we need to hear the reasons too. We need to hear all sides of this. We consider all of those comments in determining whether and how to adjust the release as we move forward. We look forward to and will benefit from your public comment on all the key areas of the proposal. So if you're weighing in for or against, it's really helpful to understand particularly where you are on each of the topics: strategy, governance, risk management, targets, financial statement metrics, greenhouse gas emissions, and particularly how you're using this, if you're using it, in terms of investing, or from the issuer side, how you're seeing it be used. And I know that some aspects of the proposal might be of interest to certain commenters more than others. But if I can be clear, we are seeking feedback on every line item relevant to you as a commenter. If you're using something as an investor, it's part of your investment decisions. It's helpful to understand those economics and what we've got right or what you think should be adjusted. It'd be good to hear from both issuers and investors, and of all sizes, from all corners of the US. That includes those who are involved in this conversation already, like your investor relations departments, your chief executive officers, your chief financial officers, and yes, as Mindy said, boards of directors. And what are investors asking of you? And how do you and your competitors decide what disclosures to make? What would help bring greater consistency, comparability, decision usefulness, if I can say that again? And what are the economics? We encourage a wide range of investors, from individuals to institutional, to hear from chief investment officers and people managing pensions and endowments. What helps you and facilitates making your decisions? That's our role. That's where we can come in and bring some consistency. So it begs the question, how do you comment? Go to really www.sec.gov. Under our regulation menu, click on proposed rulemaking, scroll down to the proposal at March 21st, 2022. There you can find the release and the comment forum, and it will be terrific to hear from as many of you as we can. And thank you, and I look forward to any questions Mindy or your others want to ask.
So we have dozens and dozens of questions coming in, and we have about 5 minutes left with you. So I'm going to try and integrate some of them or summarize them. Otherwise, we'll be here until next Wednesday. We will get them to your staff.
All right, that's terrific, Mindy. But if you want to take 10, it's all right. I'll take whatever you want. Okay.
There's some question about the Commission's legal authority in this area. People are wondering scope of the SEC authority. There are plenty of examples, I presume, but if you could address that, that would be great.
Look, I think I tried to address that just in my opening remarks. I think this is just in a long tradition. Our legal authority embedded in the 33 and 34 Acts and so forth are about full and fair disclosure. And companies are making such disclosures. The hundreds of companies are making such disclosures, and investors are currently making decisions based upon those disclosures. So our role is really to help bring some consistency. One might call it some standardization to those disclosures.
Great. Let me ask, consistency in the United States will be terrific. What are you seeing? How are we going to get aligned on a more global level when there's not a system that says every country shall have the same standards, but how do we harmonize global standards in some way?
Look, part of this is based upon the work that's already been done by these various frameworks and protocols, TCFD and the GHG. Part of it is done on a daily basis by and amongst issuers and investors around the globe, talking amongst themselves and doing something consistently. But we have a role too at the SEC, and we've been talking to our counterparts, both multilateral through the Financial Stability Board and something called IOSCO, but also bilateral. And there's barely a week that goes by that counterparts at jobs similar to mine get on the phone, or at the staff level get on the phone and compare. But now that we have a proposal out, it's best to hear from you all. What did we get right? What do we adjust? What dials to turn to, as I say, achieve that consistency?
Another question I've seen many of amongst the dozens is, what happens if companies don't do what they're supposed to do? Everyone's going to interpret it in their way. Is there enforcement that will follow up? How will you make sure it gets done?
Mindy, I hope that we sort of can get through a proposal and implement based upon comments, and I don't want to prejudge, but if we adopt, there's a number of years of implementation and the like. But yes, over the decades, we also have a large corporate finance unit that reviews filings, whether you're going public through an IPO, an S1 filing, the filings for mergers, and yes, the annual reports, the 10K. So I would hope that first implementation, then of course, consultation with the Division of Corporate Finance around review of the filings. But ultimately, sure, there's also an enforcement part of it. But I want to sort of get through the proposal, hear from the public comment, and see if we could potentially adopt and implement.
The final comment that I'll ask you, given there are a lot of questions about a broader world of ESG, which I know you're acting on, but this rule is about climate. How do we tell some of these 1,000 people what's going on beyond your important work on climate risk?
So I thank you for that. We've approaching those disclosures that are either happening now or investors find material to their investment decisions. We've put the proposal out on climate risk. We've actually, I know you might not call it ESG, but we've put out a proposal also about cyber risk, companies disclosure about their risk management strategy, and yes, even incident of having cyber risk incidents. And that's too, because this is a material thing that's going on in our economy right now, cyber risk. We have ongoing work around human capital disclosures. We have ongoing work also in the fund space about investment funds and the disclosures they make. But again, we'd like to hear from you all.
Great. Terrific. Thank you for taking the time. I know your staff will be on for a good part of this call. We'll hear from companies, investors, and from experts to drill down a little bit more on what's in the rule.
And if I can just say this, Mindy, as people listening, think about this. If you think we've got something right, tell us about it. If you think it should be adjusted, tell us. But the more detail and really line by line, and particularly how investors are using it in their investment decisions and how issuers are finding. You're having these dialogues right now with your investors, and that's going to really benefit the 5 of us on the commission.
Terrific. We will keep at it. We thank you for your work, and we'll talk soon. Thanks so much for your time. Right. I'm now going to turn this over to my colleague, Isabel Muna, who probably has blown me away in more conversations on the detail and the complexity here, but she's got the drill down. So over to you, Isabel.
Thanks so much, Mindy, and thanks to everyone. Hi, everyone. Thank you so much for joining and for your interest and for your really insightful questions. I'm Isabel Muna. I'm Director of U.S. Financial Regulation for Ceres. So it's an absolute honor to be here to share with you Ceres' reaction to the proposal. Thank you very much, Chair Gensler, for your remarks and your explanation and the invitation to folks to jump in and try to shape this rule. So I'll briefly go over a few things. So as you'll see here, I'll go over some top line reactions. I'll review a few of the key proposal features that we'd like to draw your attention to, and then we'll do some highlights of accommodations that the SEC made that the chair talked about. We'll talk about those a little bit more, and then a few conclusions for you before we go to our panel of reflections from companies and investors. So just overall, generally, this is a thoughtful and very carefully calibrated proposal. It responds directly to specific concerns that investors and issuers made in last year's request for information on climate, and it's built on the SEC's existing guidance, expectations, and disclosure reviews. And it aligns with these globally endorsed frameworks and standards that the chair and Mindy referenced, and we'll talk about those a little bit more. We also believe it will level the playing field and allow corporate innovation and leadership to be clear and more clear to the marketplace. And again, we believe it will disincentivize greenwashing and free riders. We had a number of questions about that in the chat. And we believe this is bread and butter SEC disclosure. It's well within the agency's authority. So let's go to the next slide. I wanted to just unpack just a little bit more what Mindy raised in her comments. So what did investors ask for? So what do we have in the SEC's comment file from last year? So I just want to draw your attention to a few statistics. So overall, if you look at the bottom, these gray boxes, 70% of all investors called for alignment with the Task Force on Climate-Related Financial Disclosure, the TCFD. And so of our investor network represented in the pie charts, 77% of our investor network called for that alignment. And then even though the TCFD already requires GHG emissions disclosure, separately, investors also a majority asked for GHG emissions disclosure scopes 1 through 3 with accommodations around scope 3. Over 70% of our investor network asked for that, and 65% of all investor commentators asked for that, and that's in the SEC's file. Next slide. So I also want to flag that, this proposal supports harmonization as we described, and just want to unpack a little bit about why that's important. Well, firstly, the comment file is actually replete with comments asking for the SEC to support harmonization with global standards to reduce costs and increase efficiency. So as we've heard from Mindy and the chair, the SEC proposal, like the draft IFRS standard, is built on TCFD, and they appear largely aligned. So this, oops, sorry, I went ahead a little bit. On TCFD, let me come back to that. The proposal integrates it. About 3,000 organizations support it. Major capital markets are integrating this into their regulations. And we have 8 countries moving forward with disclosure requirements. And again, it's baked into these investor initiatives and emerging global standards. Next slide. And I was moving ahead a bit to this one, which is this slide about the IFRS Foundation's effort. And what we see from the launch last year from the International Sustainability Standards Board, launched by the IFRS Foundation, we are really excited about the potential for alignment with the SEC's climate rule. This overall effort by the IFRS Foundation to launch the ISSB is endorsed by security regulators and the G20. And the convergence that we believe we will have between already the SEC climate rule and the draft climate standard that was launched by the IFRS Foundation, we think that convergence is what investors and companies are looking for. But let's go to the next slide and quickly just review the goal of these standards that are built on this TCFD. So 5 years ago, the TCFD included this very useful diagram to explain the logic of the recommendations. And this speaks to what the chair raised in terms of the objectives of the disclosure rule. So these disclosures are meant to standardize the way that the management of climate risks opportunities, and financial impact is communicated to investors. So on the left, we have climate risk. On the right, we have opportunities, which then impact strategic planning, risk management, and financial impact. And then you see the financial statement metrics and other financial information that the risk applies to. And based on this logic, 4 main categories of disclosure have been standardized in these TCFD recommendations. If you go to the next slide. So these standards, the SEC proposal, as well as this IFRS Foundation proposal, are built on these core elements of recommended climate-related financial disclosure. Again, this is a slide, this is a diagram straight from the TCFD from 5 years ago. And as the chair mentioned, it's disclosure around governance, strategy, risk management, and metrics and targets. But there's a few key metrics where I'm going to draw your attention to. So obviously GHG emissions. If we go to the next slide, I'd like to review very quickly how they're defined and why they're important. So as the chair said, the global standard for measuring and accounting for greenhouse gas emissions is the GHG protocol. It defines the terms scopes 1, 2, and 3. And just to review, scopes 1 covers direct emission sources owned or controlled by the company. Scope 2 covers indirect emissions from the use of purchased electricity, steam, heating, and cooling. And scope 3 includes all other indirect emissions that occur in a company's value chain. And so the protocol has been used by oil and gas, utilities, and many other sectors for years to build carbon inventories and track GHGs. And in fact, the GHG protocol's corporate accounting and reporting standard has been around for about 20 years, and it provides the accounting platform for virtually every corporate GHG reporting program in the world. And its scope 3 standard is about 10 years old. So it's no surprise that what we've seen is that it was endorsed by a majority of SEC commentators in the SEC's file last year. But I do want to stop and stress why investors need GHG disclosures. So first of all, they help investors understand the quality of a company's earnings in the face of climate change and the energy transition. And both current and future GHG estimates can help investors understand a company's liquidity and capital allocation strategy when faced with specific climate risks and opportunities. And while of course scopes 1 and 2 are important, and we'll talk about those in just a moment, most of a company's emissions risk is in its value chain, or scope 3. And these are the products you sell, the things you buy, and these are integral components of your business model, and therefore part of your operational climate risks that investors want to know about. So when investors consider the impact of policy and regulation, as the chair mentioned, like carbon pricing or state level energy targets, emissions disclosures help them understand the impacts on business strategy. So again, a key feature of the proposal is that it integrates these mainstream standards used to measure climate risk. But let's turn to some more specific highlights. Next slide. So again, we're very excited that it requires climate-related financial disclosure, including physical and transition risks, and the impacts on business and consolidated financials, strategy, business model, and outlook. And that, as the chair mentioned, they're filed in annual reports and registration statements, and in this very helpful note to the financial statements. But I do want to stress and compliment the chair's comments about why the filing in the annual reports is so important. So existing climate disclosures tend to be outside SEC filings, even when they're financially material. And in these cases, inconsistencies with the filings could go undetected. So unless these disclosures are in the annual report, there's no requirement that a company's auditors even read the disclosures. And under existing standards, auditors are required to read and consider whether other information in the annual report is consistent with the financial statements. But that requirement doesn't apply to voluntary reports with material climate risk information. And that's why this requirement is so crucial to investors. Well, let's keep going. So the next slide, thanks. The SEC took a thoughtful approach to GHG disclosure. And again, as the chair mentioned, for scopes 1 and 2, all companies must disclose, but with phased disclosure. And only large and accelerated filers provide investor-grade data subject to reasonable assurance after 4 years. So we'll talk about that in just a moment. On scope 3, it's only required if material or if the registrant has a target that includes scope 3. And the SEC made clear that this includes financed emissions related to investments. And the SEC provides very helpful guidance on independent third-party assurance where that's applied, either voluntary or mandatory assurance. and providing guidance on the provider and report standards. But what I'd like to draw your attention to here is this standardized disclosure of these key risk management tools, the targets, transition plans, scenario analysis, and carbon offset use. We think this is really important because these are key tools that leading companies use to manage climate risks. In the case of targets, in 2020, the majority of Fortune 500 companies has set a climate or energy target. And investor interest is increasing. For example, based on investor requests, we published a guide to climate targets last year to support investor analysis. And last year's proxy season votes show that the interest in climate risk management tools like these isn't going away. But we've also heard from companies that they would benefit from more standardization around these tools. They don't want investors to use incorrect information about their plans or deal with a variety of bespoke requests about these plans. So we think that these requirements in particular are very helpful. Next slide, please. So let's talk very quickly about the SEC accommodations that were made. We think that the SEC listened very carefully to the comments in the file last year. So there's a few chunks of accommodations we see here. Again, we see phase-ins. So phase-ins on reporting or assurance. So on reporting, it's dependent on size and by type of company. The largest companies go first, and there's between 2 and 5 years to begin preparing. There's also no disclosure mandate, as the chair said, for targets, transition plans, and scenario analysis, only if these tools exist. We also see a materiality test applied to disclosures related to strategy, business model and outlook, and also scope 3 disclosure. And around GHG reporting, there's a range of accommodations. Phase-ins, assurance for large and accelerated filers only for scopes 1 and 2, no scope 3 assurance at all, and you can use reasonable estimates in Q4 and present estimates as a range. So the commission really tried to address these concerns in the file around using estimates for GHG emissions. Again, as the chair said, we have these liability safe harbors for scope 3 and the existing forward-looking statement safe harbor. And then we have an exemption, a broad exemption for small reporting companies that represent about 40% in absolute numbers of publicly reporting companies. And so these are exemptions from the scope 1 and 2 assurance and a complete exemption from scope 3 reporting. And again, in the rule right now, this is a permanent exemption. So last slide. Just some quick conclusions here. In our view, climate is a systemic risk. It applies to all companies, and investors want comprehensive information. And the investor market demands, as the chair said, as Mindy noted, are not going away. They're only going to increase. And the materiality, coverage, and timeframes in the proposal must be examined pretty carefully with these things in mind to ensure investors have investor-grade information as soon as possible. And I'll end there, and I'll hand over to Stephen. Thank you very much, everyone. Looking forward to staying in touch with you during this process.
Thank you, Isabel. And again, for folks, there have been several questions about this, that all of you who are on this and who registered will get a copy of this. So if you want to rewatch any of it, we don't provide popcorn with it, but because there's a lot of good information here. I just want to briefly, before we get to our panel, just highlight what the chair said is we hope all of you submit detailed comments and the links. We hope you submit your own. But if you also would make it easier for you, we have what we call a statement of essential principles, and the link we put in the chat, and you can sign under that or use that as a basis for anything that you want to write. This is a historic moment. Ceres' first meeting with the SEC was almost 20 years ago, and so we've been working with many of you. So with that, let me turn this over to my distinguished colleague, the Reverend Kristen Spalding, and she is going to introduce many of the investors and company representatives to give their perspectives. Kristen, back to you.
Delighted to be with you all. I'm Kirsten Spalding, the Senior Director of Ceres Investor Network. I've been talking to our members now, over 200 institutional investor members of the Ceres Investor Network. Been talking to them every day about how to develop their own climate approaches to their portfolios, how they're thinking about managing the systemic risk of climate change across every investment they make, how they're going to develop their own investor climate action plans, their forward-looking approaches, how they're dealing with these issues as a matter of governance and portfolio construction. For every investor and company in the portfolio, this rule is crucial. Without good investable data, we can't manage climate risks. We need to measure the real economic progress that we are continuing to improve upon the long-term financial performance of our portfolios and the companies in them. So as all of us in the investment community, read this proposed rule, we read them with those objectives: producing long-term financial performance with the best data possible. I'm going to ask our really wonderful panel to reflect on what you see in the rule that serves your objectives, both as companies and as investors, and what areas of the proposal you think need more clarification or revision before the rule becomes final. I'll give you each only 3 or 4 minutes. I know it's too short, but I'm delighted to have you with us. We'll begin with Ann Simpson, who's the Global Head of Sustainability at Franklin Templeton.
Thank you so much, Kirsten. Thank you, Chair Gensler and all the other speakers. And of course, always there's a big warm thank you to Ceres for the tremendous work that you do in this area. The reason this work matters for investors is that information is the lifeblood of the capital markets. And it's also the first mandate for the SEC under its responsibility for investor protection. You look at Franklin Templeton, we're stewards for $1.5 trillion of other people's money. That's the savings of millions of people, of families, putting money aside for a rainy day, for their retirement, for their healthcare, for mortgages, and so forth. So the wider society and the economy rely upon the financial markets working properly. Now, what we welcome about the SEC's proposals is that it's focusing on materiality. That's important. At the moment, we have rather a let 1,000 flowers bloom approach, but that has led to confusion, and we also fear that it's leading to some false positives. We're only getting partial reporting according to different standards. That makes it very time-consuming and difficult to integrate that information into financial processes. So there's also a benefit for companies here. It's not just for investors, that's the investor protection mandate. We need the information. We need it to be standardized, timely, complete, accurate, and we want it to be verified. We think the approach that the SEC has taken certainly takes us to what the investor community needs and wants as fiduciaries to ensure that we're taking risks which are informed. Risk is a good thing. Risk is where we make the returns, but we have to be able to appraise risk. And, you know, as Mindy said right at the beginning, what we can't measure, we can't manage. We also see real benefits on the second part of the SEC mandate, which is capital formation. And if you look at the research evidence here, companies which are doing the better job on the reporting side on sustainability are winning a lower cost of capital. So these proposals will not just help with what companies find is survey fatigue. Typically, a big company will be receiving several hundred surveys a year, most of which focus on climate risk, among other issues. Having these standardized reporting guidelines will actually make a huge difference for companies. One is going to save them money. Secondly, it's going to give them clarity on what to focus on. And thirdly, the evidence shows it's going to improve their cost of capital. So this is necessary for investors, but it's also going to be a real benefit for companies. So we look forward to putting in our formal detailed comment letter to support what the SEC is doing. But it is a measured approach. As Isabel said, the SEC has listened carefully, it's continuing to consult. So we encourage everyone to send their thoughts in, their questions, and any proposals for improvement. Thanks.
Thank you so much, Anne. Let me turn now to Joe Amato, President and Chief Investment Officer of Equities, Neuberger Berman.
Thank you very much, Kirsten. We really appreciate the opportunity to share our views on this important topic. By way of background, Neuberger Berman is a global independent employee-owned investment management firm. We manage about $500 billion across a range of strategies: equity, fixed income, private equity, real estate, hedge funds, on behalf of institutions, advisors, and individuals on a global basis. As an active manager, we've long held that material ESG factors are an important driver of long-term investment returns, both from an opportunity and a risk mitigation standpoint. So therefore, we take a deep fundamental approach toward managing client assets including the integration of material ESG criteria into our investment process. Climate change is a global market-wide risk that needs to be understood and considered in investment decision-making processes. However, we currently lack, as has been discussed, high-quality, comparable information on material climate risks. This lack of data has made it harder for markets to efficiently allocate capital to companies that can generate attractive long-term financial returns. We've certainly seen that many companies in recent years enhance their climate assessments and disclosures, and the voluntary nature of the disclosure standards and frameworks has resulted in inconsistent and infrequent reporting. In the absence of standardized and comparable climate disclosures, investors really must resort to a reliance on estimates that are often provided by third parties, not the companies themselves. And these estimates are often based on sector or industry averages and really fail to consider important company-specific nuances. And this clearly makes for less efficient capital markets. We believe the proposed rule by the SEC will play a pivotal role in addressing these challenges. We certainly commend the Commission and Chair Gensler for responding to investors' call for climate change disclosures. Yes, we'd like to emphasize the following important points about these proposed rules. Number one, investors need consistent reporting of climate data. We strongly support mandatory standardized disclosure of a registrant's climate-related risks, including greenhouse gas emissions, and qualitative discussion of climate risks, assessments, and transition plans. Together, this information is going to provide investors like Neuberger with decision-useful information needed to adequately assess climate risk. Number two, climate change is a global risk. Importantly, the proposed rule is compatible with emerging global standards and widely accepted and adopted global frameworks such as the ISSB and TCFD. We appreciate the Commission's responsiveness to investors' calls for more global, consistent reporting. We believe the adoption of a more standardized climate disclosure framework will also help reduce the reporting burdens on issuers. Number three, climate change is a broad-based economic risk. So Neuberger invests in companies across a variety of asset classes. Just as climate change is relevant across the globe, it's also relevant to all companies. So large, small, public, and private. And we recognize that there are elements of the proposed rule that investors and companies certainly are going to be seeking more clarity on. There are aspects of the proposed financial statement requirements, as an example, in particular, that we think warrant more debate and discussion, but it remains important for companies to quantify the impact of climate change to the best of their abilities. We also believe that the proposed rule will provide much needed transparency on climate risk across supply chains and investable universes. I mean, even just as an example, earlier today, we engaged a major manufacturer whose emissions are largely derived from the use of products sold. For this company and others with similar emission profiles, Scope 3 emissions is really a critical part of the climate risk and needs to be disclosed. And then lastly, climate change is a pressing risk. So the impact of climate change is already being felt today, as has been discussed. So while the proposed rule provides phase-in accommodations for certain disclosure elements, given the urgency of climate change, issuers should really act swiftly to meet disclosure requirements. We're certainly mindful that these disclosures may contain assumptions and estimates, and we are absolutely supportive of protections such as safe harbors being provided to issuers. The last thing we want is liability concerns to create a chilling effect on disclosures. So overall, we believe the proposed rules will provide investors with information needed to adequately assess risk and ultimately improve the efficiency of capital markets. So we thank you for the opportunity to share our views, and Kirsten, I'll turn it back to you.
Thank you so much, Joe. Let me turn now to two corporate speakers, issuers who are really prepared to reflect on the rule and look at how it's going to affect their disclosures. We'll begin with Cynthia Curtis, who's Senior Vice President of Sustainability for Global Sustainability Stakeholder Engagement at Jones Lang LaSalle, JLL. Thank you, Cynthia.
Thank you, Kirsten, and thank you to Ceres for convening this really important conversation today with Chair Gensler. So for background, JLL is a global real estate services provider, and we have been issuing sustainability reports since 2010. We are about to publish our third TCFD report, And with each one of our sustainability reports or our TCFD reports, we continue to kind of push the boundaries, if you will, for us in terms of disclosure and completeness. So and the other key point of our TCFD report this year is that we did include in our 10K a summary of our findings. So we have been a proponent and a supporter of increased disclosure and transparency for a long time. And it's not only a interest that we're hearing from our shareholder investors and our clients, but the real estate sector, the built sector, is responsible for almost 40% of the world's greenhouse gas emissions. And so for us, we also look at it as a responsibility to help lead, and to help lead by example, and to lean into our purpose of shaping the future of real estate for a better world. So fundamentally, we support the SEC's proposed rule. We believe that transparency is healthy for markets. We also very firmly believe that this space is in need of increased standardization, right? So it's one of the reasons why we worked with SBTI, Science-Based Target Initiative, when we were setting our net zero goal, to be one of the companies to kind of do the roadmap with them and bring about a kind of version 1.0 of a net zero standard definition, right? So it's this would go a long way in helping to push for that standardization. So we're really excited about that. We also do appreciate that, that the comparability that the chair mentioned, and both Ann and Joe mentioned. That's important. We need to find guardrails for greenwashing and that kind of thing. So that said, we are also a little anxious is too strong a word, but we just don't want companies to be backing off of commitments. And if we look particularly at scope 3, if you haven't made a scope 3 commitment, will this make you hesitate to leaning into establishing a scope 3, because you're going to now be required, even with safe harbor, you're now going to be required to report. We're looking, at internal price on carbon. Well, if we do that, then we're going to need, by definition, to report. So you just don't want that chilling effect. And quantifying the impacts of climate change, of course, is very hard. And putting it in your SEC filing just raises, it elevates the bar. And we know that. But I would say we're in, not unlike Salesforce, we're in a better position than most because we've been doing it. So we're prepared, but it still raises the bar. So I just think we do need to just pump the brakes a little bit and ensure we get the language right for the level of disclosure and the phase in and the safe harbors, so that it promotes more disclosure and doesn't result in some of that chilling effect.
Thank you so much, Cynthia. Your last comments really highlight what I'm hearing, which is that this is a partnership between companies, the regulators, and the investors, and that we all need the best possible data to work together and build the long-term value that we're counting on. Let me turn to Joe Allenson, Financial Executive Vice President of ESG at Salesforce. What are your reflections?
Well, thank you, Kirsten. And, prior to taking on my current role, I served as Salesforce's Chief Accounting Officer and Controller for quite a number of years. First of all, my gratitude to Ceres for sponsoring this morning's briefing here, and my heartfelt thanks to the SEC staff and the members of the International Sustainability Standards Boards for all of their work and their proposals. At Salesforce, we are wholly supportive here. As we've all witnessed, there is an urgent and strong desire for a common language where companies are able to communicate with their investors the risks and opportunities that climate presents to each of our businesses, a language that is predicated on comparability, consistency, and reliability. At Salesforce, we've used sustainability and more broadly ESG as being fundamental to our business strategy. Our corporate values of trust, customer success, innovation, equality, and more recently, sustainability create more value for all of our stakeholders and are critical success factors in managing our growing business. Our investors and our analysts increasingly want to know what we are doing in the area of sustainability. This was one of the first questions they asked at our recent Investor Day. And we cannot overlook our 75,000 global employees who want to work at a company that is true to its values. We have embraced the benefits of ESG reporting. For the past 5 years, we have included ESG reporting in our 10K. We were one of the first large accelerated filers to do so. I still vividly recall the internal debates back then of how much to report, what to say, what legal exposure we might be taking on. It was quite personal to me since I was one of the signers of the 10K. But the current proposal helps to alleviate much of the anxiety that I had experienced years ago because I find the proposal quite thoughtful and responsive to prepare concerns. As a side note, our 10K reporting is in addition to our annual stakeholder impact report, which we have published for each of the past 10 years, as well as our first ever TCFD report, which showcases our continued commitment to disclosures in the climate area. We've also included our auditors into our processes from the beginning. We have historically had our auditors provide limited assurance over scopes 1 and 2 emissions. And for the most recent fiscal year that concluded, we had our auditors extend their work to include scope 3. Certainly this added work was a challenge for all involved, but the lessons and learnings proved to be quite valuable. As I wrap up my comments, I wanted to share this story with all of you. A year ago at a quarterly Salesforce Finance Town Hall meeting, our CFO invited our head of sustainability, Patrick Flynn, to be a guest speaker. Patrick started off his presentation with this very bold statement to the finance community. Accountants are going to save the planet. My immediate reaction was, one, this guy really knows how to play to his audience and possibly needs budget. But I think my other reaction was that this guy's absolutely right. As accountants, we have played an important role in business. The work that we do serves as the bedrock for business strategy, and we prepare the information that investors rely upon. Accountants have the ability to operationalize new reporting requirements and create the governance and controls over the reported information. We are also good at measuring and reporting progress to date. Needless to say, implementing the SEC's proposal is in our wheelhouse. Now, I don't want to forget my lawyer friends because putting together a 10K is a partnership with our securities lawyers. So my tagline for them is lawyers save lives. My ask to my fellow preparers, please join the conversation and the call to action by engaging with the rulemaking process. At Salesforce, we are wholly positive about the SEC's proposal. We plan to provide our feedback and highlight areas within the proposal that could be either strengthened or require additional clarification as we finalize our assessment of the implementation efforts. I encourage you to let your voice be heard as well. Thank you.
Thank you so much, Joe. And as one of those lawyers, I appreciate the tagline. We're going to turn now to a conversation with Renee Jones, who's director of the Division of Corporation Finance and really one of the experts on the SEC rule. I see that there are many questions coming in on the Q&A, and my colleagues Jim Coburn, another lawyer on Ceres staff, and Isabel Muna, who you all heard from, are answering some of those questions in real time. But we also have some questions for you, Renee. And so let me just start with the first one. I know that the SEC is looking carefully at comments that are coming in during the rulemaking process. Can you describe how the SEC is going to use those comments in the next phase of the rulemaking process?
Sure. So first, I just like to thank you for having me and for inviting me to this session. It's been really informative. I've really appreciated hearing the various perspectives that have been expressed so far. I also want to start off by just saying that, of course, the comments that I make today reflect my own views and not necessarily those of the commission or its staff. With respect to the comment process, it's really critical. So I guess I would also like to just thank everybody in the audience, all the participants who have already submitted comments to Commissioner Lee's request for public input, because those comments were very instructive and were really the foundation of our rulemaking. And again, with respect to the proposal that we've just put out for public comment, we're going to take those comments very seriously. We're going to weigh those comments. It's very important to us that we get comments on all aspects of the proposal, not just the more high profile aspects. We want to hear from investors and from companies. We want to hear from investors. How would you use the information that disclosure that would be mandated by the disclosure? We want to hear from companies about your experiences in preparing this type of information. Any of the challenges. There's hundreds of requests for comments, specific questions that we ask about the various things that we propose. And again, we're looking for your responses. We're looking for reasons why you support or why you don't support a proposal. With respect, we also would value data with respect to the cost of compliance, or also with respect to the cost savings that would be created by these proposals. So we encourage comments, we take them seriously, and we want comments on all aspects of the proposal.
Thank you. You've asked a couple hundred questions.
We have, yes.
That cover many concerns and alternative approaches raised by investors and issuers. Are there a few key areas in which the SEC is especially interested in hearing comments?
Like I'd say, we really want comments on all aspects of the proposal. And I think depending on the perspective of the commenter and their own experience, various different parts of the proposals will be more important. But the questions are there because there are obviously alternatives. We carefully consider the public input, and there were different perspectives provided. And so we presented lots of alternatives in those requests for comments. So we do really want to hear from investors, from preparers, from asset managers. And again, depending on your perspective and your role in the marketplace, we think you should focus on those areas that are most pertinent to you, where you have the most, where your comments will have the most impact.
Perfect. Thank you, Renee. We've been hearing some concerns regarding the use of estimates to report GHG emissions. Could you explain how the rule addresses the use of estimates and addresses commentator concerns?
Right. Well, of course, we want to solicit or elicit the most accurate information possible, but we realize it's not always possible to get, measure those emissions at the source point. So there are going to be instances where they use estimates, and we provide guidance surrounding those use of estimates. So we're permitting the use of estimates as long as the company is going to provide the assumptions that are underlying those estimates and the reason that they're using those estimates. And just to give a specific example, I think it was mentioned earlier, to the extent that people are providing estimates of their emissions, for example, to the extent that they're providing the disclosure of their emissions, they can estimate the fourth quarter emissions as long as it's a reasonable estimate and as long as they disclose the first 3 quarters. And so we understand, obviously, there are challenges with developing and coming up with that information, but what we've heard from investors is they're okay with using estimates as long as there's good disclosure around the assumptions around those estimates, and then they can make their own adjustments as to how much weight or how reliable the disclosure is.
Thank you. That's very helpful. The rule provides a new safe harbor from liability for GHG Scope 3 disclosures and makes clear that the existing safe harbors for forward-looking statements applies to key disclosures. Could you explain how these safe harbors work and the specific concerns that you were trying to address in the proposed rule?
Right. So we've heard a lot so far, at least I heard today that there's concerns. People are excited. Many people are excited about the prospect of mandatory disclosure and better information for investors. But from the preparer's point of view, there are some concerns with respect to liability, and even investors have some concerns. They want to elicit as much information as possible, and there are concerns about the possibility of chilling disclosure because of concerns about liability risks. So we had all of this in mind as we were crafting the proposal. So with respect to Scope 3, as the chair said, we're requiring Scope 3 disclosure. If the company has set a Scope 3 target, emissions reduction target, and or if the scope 3 emissions are material. And we've crafted a proposed safe harbor for the scope 3 emissions. So it's not a blank check from liability, but if there's a reasonable basis for those for the disclosure, and it was made in good faith, then basically there's liability protection around that, so you won't be sued. And I mean, the reasons for that are myriad. I think Chair Gensler mentioned that the methodology for scope 3 emissions disclosure is still developing. So that's one thing that a lot of companies and even investors had expressed concerns about. And then secondly, with respect to scope 3, there's heavy reliance on third-party data. And so there was concerns about being responsible or having to take responsibility or liability for the data that you're relying on if that data turned out not to be reliable. So those are some of the reasons behind the safe harbor. And generally, we're just balancing sort of the need for disclosure against the costs, and also wanting to provide incentives for the disclosure. So we want to provide incentives to be forthcoming and provide that information. And we felt like the safe harbor would provide a better sense of comfort so that more companies will provide the scopes 3 disclosure. So that's the proposed safe harbor. But there's already out there in the world, and Chair Gensler mentioned this as well, a safe harbor that was created by Congress for forward-looking statements. There's some qualifications to that. The forward-looking statements have to be accompanied by meaningful cautionary statements, but if so, there's potential protection from liability. And so we've pointed out in the release that certain of the disclosure that would be mandated would be forward-looking. So transition plans, for example, carbon pricing targets. Those are all forward-looking types of disclosures, and so the forward-looking statement safe harbor would presumably apply, if all the conditions for the safe harbor are relevant. So those are the safe harbors. And again, we really want to encourage disclosure. We want people to be forthcoming, but we do understand that there's uncertainty with respect to forward-looking statements and methodological challenges, and also reliance on third-party data with respect to scopes 3.
So let's pick up on that last thing that you just said about the forward-looking disclosures. We saw in a lot of the comments from last year, the call for disclosures of climate targets, transition plans, scenario analysis. Your proposal clearly incorporates TCFD and investor recommendations on how to standardize those disclosures, but you're only requiring these disclosures if the tools already exist. Can you explain that rationale?
So again, lots of thought went into this, lots of comments, lots of conversations with stakeholders. And again, we're trying to strike the right balance of investors' needs for information or desire for information and the potential costs. And then I think just stepping back a little bit, with respect to our mission, we're a disclosure-based agency. So, what we typically do is require disclosure, but not necessarily mandate conduct. So if to the extent that a company has a transition plan, is using scenario analysis, has an internal carbon price, that's information that's valuable to investors. So if they're doing it and the information would be valuable to investors, requiring its disclosure, although it's not burdenless, it would be low cost. If there are lots of companies, and lots of companies are doing it, so that information will be provided to investors in a very standardized form. And so the benefit, of course, of the TCFD framework is it provides a framework for standardization. If companies aren't doing that and they had to start to do it or learn to do it, that would be burdensome. So we're trying to, again, balance the benefits against the costs. And it may be that the companies that are providing that disclosure, that's where it's going to have, it could be that's where the greatest benefits are. And so investors are potentially getting the information that they need.
Yeah. And I do expect, from my conversations that we're going to continue to see investors asking for those transition.
That's what we expect.
Yeah. And so as the companies, step up and begin to comply with the plans, then they'll be required to disclose. Thank you for that.
Exactly.
You've included in the rule some important materiality tests for disclosure. Could you explain how those work and to which disclosures do these materiality tests apply?
Right. So with respect to sort of impact and strategy, again, we're looking for impacts of climate-related risks that are material to the investor. So, or material to the company. And we're using the materiality analysis, which is pretty much a standard tool for any kind of disclosure program from the issuer's perspective and also from the SEC's perspective. So it's a standard and a tool that's familiar, or should be familiar to all companies and to investors. And we're incorporating the materiality standard that, of course, was been created or announced by the Supreme Court. What's important to the reasonable investor. With respect to Scope 3, there's a materiality qualifier. So companies will be required to disclose their Scope 3 emissions after a phase-in period if they're material. And there's very, I think, helpful guidance in the release as to how companies would make that materiality determination. And it was alluded to earlier in the conversation, but to the extent that the Scope 3 emissions are the most significant proportion of the emissions, and in certain industries, for example, that are under transition, we would expect the Scope 3 emissions would be material to investors. And like I said, there was a couple of examples in the release, including maybe the automobile industry or oil and gas industry, where there is potentially going to be a transition, and they would be facing stronger transition risks with respect to either government regulation or customer demand or the availability of financing. So that's how the materiality standard works. And again, if the information is important to investors, we're going to require it to be disclosed.
Thank you. It's really good to get your explanation of that. Can you talk a little bit about the footnote disclosure in financial statements and why the SEC is proposing 1% as the right level of impact, and key questions for commentators to address as they look at that particular section of the proposed rule?
Yeah, so a lot of, I think Chair Gensler mentioned this as well, a lot of the proposal is focused on risks and very forward-looking, but the financial statement disclosures are more current, soliciting more current information, and we're looking for companies to disaggregate the impact of climate risks or climate events on the financial statements by line item and a note to the financial statements. And so we're looking at the impact, for example, of climate events, right, on companies' revenues or losses or insurance losses. And if it's an excess of, if it's 1% or more of a line item, it would be required to be broken up, disaggregated and broken up and disclosed in the note to the financial statements. So, physical risks or the physical impacts and also transition impacts would need to be broken out by line item. And the reason the 1% is just to provide a bright line rule. So it's not necessarily a materiality standard. It's just to say, so people don't have to make the judgment as to what they need to disclose, like per se, like here, this is a bright line standard. We're going to get standardization. Investors are going to be able to see how climate change or climate events impacts transitions are impacting the financial statements right now, and take that into account in their analysis. And the 1% threshold has been used at other points in time with respect to certain estimates. And so it's a measure that I think companies should be familiar with.
Terrific, thank you. The rule requires assurance of GHG emissions scopes 1 and 2, but allows the assurance to be provided by non-accounting firms as well as accounting firms. It also didn't require the assurance on scope 3. Can you talk a little bit about why and how the SEC made these choices and what kind of input you're looking for in this area?
Yeah, so we've definitely been getting a lot of questions about the assurance requirement. And again, we're looking for standardization, comparability, and decision usefulness of the information. And there's evidence that shows that when there's assurance provided over disclosure, investor confidence goes up, and that obviously is going to be aiding in investor decision-making and capital formation. So the proposal says that for scopes 1 and 2 emissions after a transition period, and then again, it's phased in depending on the size of the issuer, there will be an assurance requirement starting at the limited assurance level and then transitioning to a reasonable assurance level. It could be provided by a PCAOB auditor, but it doesn't have to be. So it could also be provided, for example, by an engineering firm, for example. So if the assurance provider has the requisite expertise and is using standards that have been gone through a notice and comment, publicly published and gone through notice and comment, and are sufficiently independent of the issuer, they would be allowed to provide this assurance. Scopes 1 and 2, because it's there's a little bit more certainty in terms of how we measure scopes 1 and 2. It's scope 3 methodologies, we've said, is still developing. So the the assurance requirement will apply to scopes 1 and 2 after a transition period, phased in based on the size of the issuer. Smaller reporting companies, of course, exempt from scope 3 and would be also exempt from the assurance requirement in most instances.
Thank you. I know when I talk to investors about the auditing and the financial statements that this is a matter of core governance. So it's not
Yes.
just the disclosure. It really is about how well the company, does the disclosure, how well they manage the risks. And so it's all related. Thank you so much, Renee. I want to just give you 1 minute before we hand it back to Stephen. Is there anything I haven't asked that you'd like to highlight for our audience today?
No, I would just like to repeat Chair Gensler's message that we really are looking for public comments. We welcome the comments and we will be studying and carefully reviewing the comments as we shape a final proposal.
Thank you so much. Over
Thank
to
you.
you, Stephen.
Kristen, thank you for all that you do. And Renee, to you. And Renee, through you, I just want to take this time to thank all of the SEC staff that have worked so hard on this, the chair, the commissioners, starting with then acting chair Lee, who kind of kicked this off last year. And we know that hundreds of people have worked hard. So we really want to thank everybody. We also want to thank everyone who has listened today. This is a very important issue. And as you heard, your voice really matters. So between now and May 20th, the SEC wants your perspective. We also want to work with you. Ceres will be filing a comment. We're going to say a lot of what's been said in terms of there's a lot of great things. There are a few things that we will want to encourage the SEC to go a little further, a little faster on. But overall, we understand why they've calibrated a lot of what they put in there. We look forward to working with you. If you have additional questions, you can go to our website, ceres.org/SEC, or sign up for more information. You'll be getting a copy of this with all of our contact information if you want more. So again, thank you to all of you. We look forward to together providing lots of detailed comments to the SEC, and then they'll go through their analysis. And through that, will help all of us ensure that our financial stability is secure, not just for this year, but for the future. Thank you and have a great day.